You're watching Fox 13's Good Day Tampa Bay.
Hey, it continues to be Ask a Lawyer Day here at Fox 13 all morning long. Our attorneys are here in studio taking your phone calls, answering any of your questions. Our buddy Betsey Herd is here to talk about medical negligence and the Three Strikes Amendment. First of all, let me say it again. You and your friends from the Hillsborough Bar donate your time every month to come in here and do this. We appreciate it very much.
Thank you.
Good to see you. All right. Three Strikes Amendment. Remind us what that is.
So back in 2004, the voters voted in an amendment to the state constitution that said that any adjudicated claim, so there has to be a judgment, an arbitration finding, a doctor gets 3 of those and then he loses his license, has his license revoked.
Okay. Now, that's what the voters voted on and approved?
Correct.
But it's not working in the way that they may have thought it was going to go.
Right. So it was always intended to be judgments, and so you've got doctors who have, I know of a couple of practitioners who have had numerous claims, but they're still practicing because they resolved those claims. So that amendment was always designed to have doctors who make mistakes do the right thing and resolve those claims, but you only have your license revoked if you have 3 judgments.
Got it. One of the things you want to say is how a person can do their homework on their own to find out about their potential doctor.
So
or their existing.
There's a statute that requires when a patient asks a doctor, have you had any incidents that caused serious bodily harm, whether that harm was the result of negligence or because the procedure is risky. A patient can ask a doctor about that, and the doctor has to respond and give that information to the patient because it gives a patient information about how risky a procedure is. If it's resulted in serious bodily harm and there's been no negligence, then that patient needs to be advised of that risk. If the doctor has had a claim that where negligence was alleged that resulted in serious bodily harm, that has to be disclosed as well. The other thing that a patient can do is his own research. There's a website, floridahealth.gov, where you can get to all the licensed professions are listed there. You go to physicians, hit that screen, and it will pop up, what do you want to know about that, about a physician, and you can research claims that that physician may have had. On the first screen, there's going to be claims that are recently reported, and then there's another screen that you can get to where it says, for more information, click here. You click on that, and it takes you to the closed claim insurance database. Because the first screen is way behind. The Department of Health, they're seriously behind in getting incidents or claims reported on that first screen.
Yeah. Well, I mean, and let's face it. It's going to be a whole lot easier for you as a patient to click on a website than it is to be face-to-face with your doctor and say, any claims against you? I mean, that's hard for a lot of people to do.
For a lot of people it is, but for some people it's not. And let's face it, if you're presented with a consent form though, and there's death listed in the consent form, that's the time to ask. Doctor, I was looking at the consent form, and there's this area here where it says that it could result in death or serious incident to my organs. Have you ever had that happen before? That's what I would do.
And the important thing that you brought it up, but let's stress that again, they got to answer that.
Right. There's a law. If they don't want to answer it, let's get a second opinion.
And there it is. Hey, good to see you, my friend.
You too.
Love you very much. Thank you very much.